Right. Well, we all know that the judicial power of the state is granted in the Constitution. And here in Ohio, Article 4 of our Constitution establishes the judiciary. And the primary function of our judicial branch is to resolve disputes in a very civil manner, to settle disputes according to law, and at the appellate level to review decisions that have already been made to make sure that they are in accordance with law. Also to interpret ambiguous statutes. At the top of the list, of course, we have the Ohio Supreme Court, and we call our official title is actually the Supreme Court of Ohio. A lot of people don't know that. That's just something, new attorneys that are able to say Supreme Court of Ohio, you kind of get an extra star because you know how the court is supposed to be spoken of. We have the ability to pick and choose our cases for the most part, and that's called discretionary review. It means that not every case that comes knocking at the door of the Supreme Court is going to be heard by the justices, because we may choose according to what comes in front of us. 4 of the 7 justices, at least, must choose to take a case before it's actually in. And we also have original jurisdiction, meaning that the case is going to come to us first in a certain number of cases. We hear cases involving writs of habeas corpus, of course, meaning that somebody has been unjustly imprisoned or they want to get out of prison. We can hear writs of mandamus, where we are being asked to order that the official performs a certain act. We may be asked to issue a writ of procedendo, meaning the court should proceed to do something, or to the contrary, a writ of prohibition, meaning the court should not do something. And we finally have the writ of quo warranto, which is a special writ issued against a corporation or a person for misuse of their authority. We hear all appeals from death penalty cases, and we hear a number of appeals directly from the agencies, such as the PUCO and the Board of Tax Appeals, for example. When we issue our discretionary cases, or the appeals on the discretionary cases, we have decided that those cases were of great general interest, public interest. That's the standard that we use to determine when we take a case. Every case, though, has a chance to be appealed at least once. There are 12 district courts of appeals. The Intermediate Court of Appeals is the level right below the Supreme Court. Every county is within one of the 12 districts. Some counties have one court. For example, Cuyahoga is the 8th district, Franklin County the 10th district, Hamilton County the 1st district. But there are other districts that have a number of counties within their jurisdiction. One of the most important parts of our jurisdiction, of course, are the issues of constitutional interpretation. Those cases will come to us on appeal, and we hear every constitutional argument that is presented. We will also hear conflicts between the districts. Let's say the 6th district has decided a case one way, the 1st district has decided it another. If one of those courts will certify the conflict, meaning it says, yes, we have decided this issue differently and we need the Supreme Court to make a determination who is correct, we will take those cases as well. Every single one of the 88 counties has at least a court of common pleas and may have the general jurisdiction, the probate division, the juvenile division, and the domestic division all in one court. Those are generally the rural courts that will do that. Many of the municipality or the areas that have a large population will divide the courts into the separate divisions that I talked about. And when we look at our chart again, you will see that the general division will hear all of the criminal felony cases, and we'll hear cases where the amount in controversy is generally over $15,000. And the general division will have both the civil and the criminal together. If there's a domestic relations division, that type of court will hear the divorce and the dissolution cases, of course, legal separation, spousal support, allocation of the parental rights and responsibilities for children. Sometimes the domestic division is combined with the juvenile division, and in that case the court may be called a family court. But again, remember, it's part of the Court of Common Pleas. If there's a separate juvenile court, which oftentimes happens, they will hear the cases involving children 18 years, under 18 years of age. They can be the juvenile, I guess we would call them the delinquency cases. They've used that term in the past, but generally those are the cases where someone's been charged with an offense that would be a crime if they were an adult, and there are special procedures for those cases. The court also involves paternity cases, child abuse, non-support, and failure to send children to school, which I always think is an interesting wrinkle for that jurisdiction. As to the probate division, everybody, I think, is aware that's where the wills are proved, and if there are will contests, they are heard there. But they also have the distinction of being the court that issues the marriage licenses and handles the adoption proceedings. Any hearings on sanity or mental competence will be heard in the probate division as well. And then the statutory courts, the municipal and county courts. These are created not by the Constitution but by the General Assembly. And when there is the need for a county court or a municipal court, the General Assembly will actually statutorily approve that. So most of our cities do have a municipal court, and if their jurisdiction extends throughout the county, there's no need for a separate county court. We call them courts of special jurisdiction, and that means that they do not have the unlimited jurisdiction that common pleas courts have, but they can hear civil cases up to $15,000, and they can hear preliminary hearings on felony matters, then have those cases bound over to common pleas, or they could handle all the misdemeanor cases and traffic matters. We have the Court of Claims, which is in a separate area on our chart, and that's because the Court of Claims is a special court. It involves cases when the state of Ohio or any of its agencies are sued as a defendant. This is a special court where there can be a panel of 3 judges, or there may be a single judge to hear a particular case. If the case involves less than $2,500, it's going to be done at an administrative level. But if it's higher than that, the case will be heard by, as I said, the panel or the single judge. And interesting there, because this involves money, and it usually is an award against the state, these cases are not appealed any further. The Court of Claims is where the case is heard and where the case is finally finished. Mayor's courts, people may realize that there are mayor's courts, and it's interesting because they are not courts of record. Although they do still have to file statistics with the Supreme Court, as all the other courts do. And the mayor's courts are presided over by the mayor of a particular city. If the population is more than 100, there can be a mayor's court, but they have very limited jurisdiction only over traffic matters and state traffic laws.